Hey guys, welcome back to the channel. Today we've got not one, not two, but 3 wild videos lined up for you. Kicking things off, we're heading into Judge Perkins' courtroom, where a sovereign citizen, Karen, tries to pull the usual script, but Judge Perkins isn't having it. He moves right past her nonsense to focus on the people actually there to handle business. Let's dive right in.
This is the city of Detroit, Mr. Berry versus Destiny Graves, case number SB 1069059, counts 1 and counts 2, SB 172478881, SB 1724805, counts 1, 2, and 3, and SB 1724836. Appearance for the city, Mr. Berry.
Elwood S. Berry Jr. on behalf of the defendant. State your full name, Ms. Graves.
Good morning, Your Honor. I am Destiny Raven Graves. That's capital D, lowercase ESTINEY, hyphen, capital R, lowercase AIVYN, colon, capital G, lowercase RAVES. I am appearing specially and not generally. I am here in good faith and under the protest solely to address the matters raised in my plea abatement. I am not here to delay the process, but to ensure proper identification and lawful jurisdiction are established on the record before any further proceedings.
All right, good morning to you, ma'am. Today is the date and time set for arraignment on the bench warrant. Would you like counsel to represent you or no?
I'm sorry, can you repeat that?
I said today is the date and time set for arraignment on the bench warrant. Would you like counsel to represent you or not?
I actually am not open to proceeding until we establish jurisdiction over the living woman. That's me, lowercase ESTINEY, hyphen, capital R, lowercase AIVYN, colon, capital G, lowercase RAVES.
Well, guess what? You're standing in court right now. That means personal jurisdiction is already a done deal. And since the charging documents look properly filed, subject matter jurisdiction is locked in too. In short, yeah, jurisdiction's been established.
If you are Destiny Graves. If you're Destiny Graves, if that's your name, then unless you have some other view of the court rule and you cite a court rule, the court is going to feel the jurisdiction has been established.
I understand, Your Honor, but respectfully, the name in all caps represents a corporate legal fiction. I am here as a living woman, not as a surety or a fictional entity. I respectfully require the court to establish, for the record, how to obtain lawful personal jurisdiction over me, the living woman, separate from that entity.
Well, I'm going to enter a not guilty plea on your behalf. I'm going to give you a $0 bond. I can either give you into the breakout room with the city with an attorney, and he can help you proceed, or you can proceed and speak to the city attorney yourself to see if you can work this matter out, or I can set a jury trial date and the matter will be resolved on the jury trial date. Which one would you like to do, ma'am?
Are you asking me if I would like to proceed for trial?
Yes.
I would respectfully, Your Honor, I would like to reserve all my rights under the UCC 1-308, and I object to these proceedings under protest and duress. My appearance is special and not general. I do not consent to the court assuming jurisdiction through presumption. If this court insists on moving forward without proving lawful authority over the living woman, I must note a violation of due process for the record.
Okay. So, I mean, if you can't give me an answer to my question, then I'm going to put you back in the waiting room until you can figure it out, and we'll move on to the next person.
What is your question, Your Honor?
I asked you, do you want to see if the attorney can get you an offer and speak with the attorney? Or would you like to work out an offer with the city yourself to resolve the matter? Or would you like me to set a jury trial date? Those are your three options. You keep on saying that same stuff is not going to change what your three options are, okay? So that's that. I don't need to hear that same recitation of what you just mentioned a minute ago. Now, what do you want to do?
So I'm sorry, respectfully, Your Honor, I do want to know, is this denying the abatement plea?
All right, so Judge Perkins decided to pass on this one. Probably because he's not exactly a fan of the crayon-flavored nonsense sovereign citizen Karens love to dish out. And surprise, surprise, she chose to leave and never come back, earning herself a shiny new bench warrant. Now, let's move on to our next case. Not a sovereign citizen this time, but a full-blown biblical fundamentalist who's convinced the Bible says to avoid lawyers at all costs, even if that cost is, you know, their own freedom.
All right, this is cause number CR 22-368, State of Texas versus Seth Edward Atkins. All right, Mr. Atkins, the state has filed a motion to adjudicate your guilt and to revoke your community supervision. I want to take a moment and display on the screen their allegations before we have a conversation about whether or not you want to proceed and represent yourself. Okay, can you see that on your screen?
Yes, sir. Hold on, okay. Can we go back up? Just fine.
I don't want you to say anything. I just want you to read.
Okay. Yes, sir. Yes, sir.
All right, so Mr. Atkins, I don't want you to say anything other than to answer my questions that are going to be limited to the discussion of whether or not you want to represent yourself. Now, that's been indicated to me by Ms. Tabraham in your own words without telling me anything about these allegations or your case, why it is that you want to represent yourself.
I don't really trust lawyers anymore, and I'm more than qualified to represent myself.
I get it, not everyone trusts lawyers. But refusing their help when your freedom's on the line? That's like not trusting a neurosurgeon to remove your brain tumor and deciding to perform the surgery yourself. It's bold, but also unbelievably stupid.
Lawyers.
Good book says that they're bought and paid for. Bought and paid for, man.
The good book being the what
The whole
book?
company. The whole company.
And where does it say in the Bible that attorneys are bought and paid for?
Jesus had a whole conversation with a lawyer who searched after his own righteousness and showed him the way. So,
And Jesus in the red word said to be weary of lawyers because they're bought and paid.
don't trust them.
It says don't. And where does it say that?
Do you want me to get it for you?
Yes.
Spark, can you please look up which verses? I know it's in Matthew and John, but I want the good one where Jesus has the conversation with the lawyer. Thank you, Mr. Flynn.
You have to be careful not to take person's
Oh, I know. It's all about just seeking after your own righteousness and how all sin is evil. This Bible, right? It's not just in the Hebrew Bible?
It's quite a few verses.
It's a bunch of them. I don't know if King James and the Council of Nicaea decided to take out that part or not. Sorry, Mr. Martin.
Okay, take your time.
Yes, sir. I'm sorry for all of this. I really am.
Okay, take your time. Find the verse, find the scripture that you found it to.
Not in the way that, it's not in the way that all of them are bought and paid for. But I know how bureaucracy works, and
Well, I don't want to get too far from what you said earlier. You said that the Bible says, that God's word says, do not trust lawyers because they are bought and paid for.
It's because the law, men of the law search after their own righteousness.
No, sir. No, sir. You said that that's what the Bible says, and that's one of your grounds for why you want to represent yourself. You read to me the book of the Bible, the verse, the chapter, and I want to know if it's Jesus's words or if it's someone else.
Yes.
And if you don't find that and that's not in there, then you come back and you tell me it's not in there.
Yes.
And move on to the next one. But I don't want to move into talking about self-righteousness and bureaucracy. So go ahead and sit down and read through the Bible and tell me where it's at and tell me when you're ready.
I consider it too bad.
Hey, Your Honor.
Go ahead, Ms. Jackson.
Okay. So the verse has been taken out of this Bible. In the Hebrew Bible, it's in there. I know where it's at. If I had my scrolls and stuff, I could show you.
Obviously, he's talking about the Dead Sea, but let's be real, this guy's way off track. I'm not exactly a religious scholar, but I can tell you what he's referring to. In the Hebrew Bible, specifically Isaiah 10 verses 1 to 2, it says, "Woe to those who decree unjust laws and to those who write oppression, to turn aside the needy from justice and rob the poor of their rights." Now, back in ancient Israel, the job of a lawyer didn't even exist. So this verse isn't condemning lawyers. It's calling out corrupt judges and twisted justice. Big difference.
So if you want to give me a court-appointed attorney, then go ahead. Please, sir.
Do you want a court-appointed attorney?
I just want y'all's help to fix all this. But yes, I would.
Okay.
I would like a
Well,
court-appointed.
you told my coordinator there that you wanted to represent yourself, and you do have a constitutional right to represent yourself. However, as the judge, it's my job to ensure that you are adequately warned about the dangers of doing so. So I wanted to give you an opportunity to tell me why you wanted to represent yourself. And obviously, that's the first thing that you've said to me is that you have a religious belief that that Christ said not to trust lawyers because they're bought and paid for. If you can't prove that to me, then we can go on and we can talk about your other points. We can talk about your education, we can talk about your legal training, talk about your familiarity with the rules of criminal procedure. We talk about the advantages, the disadvantages. We talk about your rights. We can have that discussion. I have no problem with it, but I want you to be heard first. And then it's going to be my opportunity to evaluate whether or not I think that it's appropriate for you to have a court-appointed attorney or rather to represent yourself. If you insist on representing yourself, then I will do my job and I will go through the threat of warnings and I'll weigh that. I'll make that decision. If you're telling me that you have a natural distrust of lawyers, okay, that's fine. But you understand, Mr. Atkins, though, that even if an attorney is appointed to you, you make the decisions on what you want to do, whether you want to play true to something, play not true to something. You and you alone get to make that decision. No attorney gets to substitute their decision for your decision. So you are in control. The attorney works for you and helps you to understand the law, helps you understand the weight of the evidence, it helps you understand how to make an informed decision based on the allegations against you. Now, we find that you're indigent and that you are eligible for court-appointed counsel. If you want court-appointed counsel, that attorney will be appointed to you, and then you can discuss the case with them, and then they come and obviously they make the arguments before the court, and they are your representative in court. And at this point, you have an opportunity to have one of two things. You can either negotiate some kind of agreement to resolve the accusations, or you can request to have a hearing in which the state of Texas through their prosecutors will be, they'll bear the burden of proving the truthfulness of the accusations beyond the preponderance of the evidence. It's a lower burden. because it is a revocation and it's not a trial on beyond a reasonable doubt. And if they approve that, then you could be revoked and sentenced anywhere from minimum 2 years up to 10 years in prison and a fine not to exceed $10,000. Some of these things I know that you're already aware of because we had this discussion before you were placed on 10 years of deferred adjudication. So if your position is you want to represent yourself, then let's carry on. We'll talk more about it. If it's not, that you do want the assistance of counsel, then let me appoint you an attorney and then let's carry on.
Can I just ask you a question, Judge Martin?
You can, but I don't want you to say anything that could be used against you in court. Okay?
Okay.
All right, go ahead.
You know, I'm not one to let people just keep pushing me around. You know what I mean? Like, I do freak out. I mean, I do lose my cool sometimes, but it's never been without justification. You know what I mean? Like, my grandmother's husband pulled a gun on me. I got aggravated assault charges behind it, all because he still to this day bullies my Down syndrome uncle, who hates living over there now. And I can't be there to protect him because of him. You know what I mean? And try to tell y'all that he pulled a gun on me. My grandma told y'all he pulled a gun on me. Nothing ever happened. Got picked up on this charge. Someone tried to steal my truck, hit me over the head with a bat to where I'm bleeding down my head. No one even bats an eye. Doesn't ask any questions about who hit me, why they were trying to steal my truck, whether or not I want to press charges. I've always had y'all's back.
You're walking a fine line here. One wrong word and you could end up digging your own legal grave. The emotion you're showing right now is exactly why you should accept that free lawyer. They're not here to judge you. Their sole job is to protect your rights and minimize the damage. And honestly, that's the smartest move you can make in your situation.
Charges about an assault. There's nothing in there. It says that you didn't show up to probation, you didn't pay your fees, you didn't do your community service, you didn't take a class. It has nothing to do with any of the things that you've mentioned. Okay. So at this point, to resolve those, if you have evidence that rebuts that or mitigates that, then that's where we have to get to in the process. And the only way to do that is either represent yourself with the court's permission or have an attorney that works on your behalf that you give information to, and they argue to the court how you're not legally liable for these charges or that they should be mitigated because of your circumstances in life. That's what we're trying to get to. Obviously, today is not going to be a resolution. Today's not the resolution. Today's not the hearing for that. Today is what we call a pretrial type hearing. And so the only issue before you and me right now, Mr. Atkins, is who's going to represent you? Is it you? Or is it going to be an attorney that I appoint to represent? And I just need to know, if I appoint an attorney, are you going to work with them and do your best and let them represent you? Or are you going to be difficult and grieve them and file complaints and make accusations?
I've never given y'all problems like that, Mr. Martin.
I'm not saying you have, Mr. Atkins. I'm not saying you have, but I'm just saying I have to ask that question because if you believe that there's a religious conviction that you should not accept the help and assistance of an attorney, that may be an underlying motive for you to not work well with an attorney. So I like to know these things going in. And of course, I've been in this position many, many times. And so I've learned over the years to ask these questions because I've seen this become an issue with people in the past. And I just need to know if that's going to be you, then let's don't talk about having an attorney. Let's talk about representing yourself. And if you're going to be able to do so intentionally and knowingly, that you're forewarned on the disadvantages of self-representation.
No, I guess. Will you please appoint me an attorney?
Now that's the first smart thing you've said all hearing.
Yes, I will. I will do that. So Ms. Tabraham, do you need any paperwork from Mr. Atkins?
He's not completed the affidavit, but,
Go ahead and have him complete the application.
okay.
I think I already know what the finding is going to be, but we do need this for our compliance with state law. So fill out the affidavit of indigency, request for court appointed counsel. Let us review that. If you meet the qualifications, and I'm pretty confident you will, then the court will appoint you an attorney. I believe in your underlying case, you were represented by Mr. Jeff White. Is that correct? And I believe, I think I remember that's someone that your family members hired for you. Is that correct?
Paper out of my money, but yes, sir.
All right. Do you have money to hire an attorney?
No, when I went to prison, I gave my mom the rest of the money that I had. She blew it.
All right, then just go ahead and fill out the paperwork, and then let Ms. Tabraham tell me where we stand on our appointment process. Okay.
Sure.
All right. You can go ahead and have a seat. You don't have to stand.
And I've got Preferred Credit Union versus Franthia Price next. Is that all right?
Yep.
We are here in the case of Preferred Credit Union versus Franthia Price, case number 25-05340AE. This hearing is being recorded on Zoom and live streamed on YouTube.
And this matter is before the court for a motion today, although it was not clear to me what the nature of the motion is. So as an initial matter, Ms. Price, would you state and spell your full name for the record, please?
I just want you to know, Your Honor, I'm here specially, not generally, and do so sui juris as the authorized agent for the family, Franthia family of the Price estate. So my appearance is strictly limited to the matter noted today, and it does not grant any joinder to general jurisdiction, nor does it have any waiver of rights or implied legal disability or association with any bar guild.
Well, I get it, Ms. Price. However, I can tell you that I'm a general jurisdiction court. I operate under the United States Constitution and the Michigan Constitution, and those are the only things that give me jurisdiction to act or make any decisions. So if you want me to decide anything in your case, you're going to have to be within the jurisdiction of my court. So, and we don't have to hammer that completely out at this time, but I do need you to state and spell your name.
Franthea, Franthia.
All right. Last name Price, Price.
I am.
Very good. And Mr. Bakikuo, would you place your appearance on the record, please?
Thank you, Your Honor. May it please the court, Stephen Buquicchio, Buquicchio, P number 62076, on behalf of the plaintiff Preferred Credit Union.
Very good. And Mr. Bakikuo, this is not you.
A bit confused as to what the relief she's seeking here. I'm prepared to assert Preferred's position legally here, and we'll wait for the court's direction as to when I can speak on that.
Very good. Well, let me go back to Ms. Price, because it's her that initiated this motion appearance. What are you asking me to do at this time, Ms. Price, in a legal sense?
I respectfully request that the court take judicial notice pursuant to MRE 201B of the following two documents I previously filed into the court record. One is Exhibit J, OC 10, subpoena duces tecum, demand for custodial records. And number two, supplemental notice of clarification regarding the constructive subpoena duces tecum. These materials, Your Honor, are supported by the Federal Reserve Operating Circular number 10, Appendix 3, UCC Article 8, subsections 8, 102A, 14, and 15, 12 CFR, subsections 225 and 31 CFR, subsection 203, which collectively...
Let me just pause you just a minute, Ms. Price. The one thing I recognized of everything you said there was the Michigan Rules of Evidence and the term subpoena duces tecum, meaning you're directing a discovery subpoena. Is that directed at Preferred Credit Union?
It is, sir. I also wanted it to be on record because I previously asked for debt validation and didn't get anything in the lower courts. So
Okay.
Your
Well,
Honor, may I respond?
yeah, go ahead, Mr. Mercutio.
A couple things, Your Honor. There's a lot to unpack there. Number one, we have a judgment in this case, so any attempt for discovery is outside, respectfully, the jurisdiction of this court at this point. I suspect what Ms. Price or the estate of Miss Price or the Franthea Price family of Price estate is seeking to do here, Your Honor, is undo the judgment that was legally entered in the lower court case. So I would just say, Your Honor, what she's asking for is irrelevant and outside the bounds of what this court can do. The case is over as far as the district court is concerned. I can get into the argument as to the debt validation. I did produce with our response a motion for summary disposition there that did provide for the debt validation notice. Ms. Price continues to mislead the lower court and now this court that a debt validation was not given. It was in fact given. This is a simple credit card case, and she is trying to use far-flung, just I can't even characterize what these arguments are, Your Honor. I want to be respectful of Ms. Price's ability to defend this in pro per, but
I object, sir. I'm not in pro per. I'm sui juris. Thank you.
okay, whatever that means, Your Honor. This is making a $12,000 credit card case so much more for my client, and Ms. Price, pursuant to the agreement, is responsible for those attorney fees. And I know there's a fine line between allowing a defendant in pro per or sui juris or whatever the name she's calling it, but this is just abuse of the process, Your Honor. She is alleging things that have no legal bearing whatsoever. She's asserting UCC, bill of cost, bill of ladings, bill of exchange, foreign bill of exchange. Your Honor, I don't even know what this means, to be quite honest, and I've been doing this for over 20.
One thing I did see that I did recognize as I paged through the file was the affidavit of transcript of the lower court record, which is normally produced in a case that comes before me on appeal of the district court decision. Are you aware of a notice of appeal filed?
I am not aware of that, Your Honor. I suspect what was done here, Your Honor, was in the lower court. The judge indicated to Ms. Price that she's ruling in favor of preferred and she was welcome to appeal that. And I suspect this is her attempt to appeal that. And to the extent Your Honor is ready to rule on her appeal and either, overturn the lower court's decision on the judgment or some other ruling here, I'm going to proceed as though she is seeking to undo the judgment that was entered against her. That's all I can surmise by this, Your Honor.
Yeah, if I may speak.
Yep, go ahead, Ms. Price.
I believe the opposing counsel has stated he has not received an appeal. I have sent that. All the information you received, he's received that. I have the record that the hard copy receipt from the post office. I sent this certified mail. So I do have the receipts of all of those things. Whatever you have, his office received it as well. I do have the proof of service and all that. The fact of the matter that he continues to mischaracterize this as solely a simple credit card debt that I'm trying to avoid, that is simply a mischaracterization of what I'm attempting to do, as is unsupported on the record that I've attempted through bill of exchange, and I've asked and requested and have not received a simple application. A copy of it is not supported of the verification that this is a bona fide contract. And lawful consideration, if it's not done, is violation.
Where I sit on this one, Ms. Price, is that my position legally here is I'm the court of, I can sit as the Court of Appeals to review the judgment in the district court. And what I appear to have in front of me here is a partial appeal in that I do have the record, at least at what looks like to me, it's not a full record. It's just a transcript of the summary judgment hearing at the, in the district court in Kentwood. Normally, when I get the record from them, it has a whole bunch of other documents that explain, in a nutshell, how that case was reduced to judgment. And I don't have that, so I don't appear to have an entire record. And what I don't have from you specifically is a document called a notice of appeal that tells me that you're appealing a final judgment and that you want me to review that for its legality. I can tell you, because it is on appeal, it follows the appellate rules of the Michigan court rules, and they are, for lack of a better term, more intricate and harder to follow than the general court rules or the court rules for proceeding in the district court or in the circuit court. There are a lot more hoops to jump through on appeal, and that's really where you are when you're in front of me. And I can also tell you that on appeal, what I'm supposed to do is look at the record that was generated in front of Judge Sturkenberg, and the new stuff that you file with me, arguments or requests for discovery. Mr. Bequicchio is accurate in saying that normally you don't get any additional discovery on appeal. Normally what you do is you make an argument on what happened below, and that might include that Judge Sturkenberg denied you proper discovery, and that thus she made a legal error that warrants me overturning that case or sending it back to Judge Sturkenberg for more work or things of that nature. And I can tell you, from what I see in the file right now, I don't have the information I would need to decide that. So what I am going to do is direct you to file the requisite notice of appeal and appeal documents within the next 15 days, or I will dismiss the appeal, and you'll have to start that process over again. And the dismissal may have a substantive effect on your ability to file another appeal. So what I'm telling you is this appeal that's in front of me right now is incomplete. It's not documented per the appellate rules, which are found in the Michigan court rules. And, I wouldn't have any choice but to dismiss it unless you supplement it with at least bare minimum a notice of appeal and sufficient information to inform me and Mr. Bequicchio what the nature of your appeal is. What that it appears that you're appealing from a final judgment. However, all I saw in the final judgment, I think, was the fact that Judge Sturkenberg did grant that on the record. I didn't see. Do you have a judgment in order that you filed, Mr. Bequicchio, a written order in connection with that?
We do, Your Honor. A judgment was indeed entered subsequent to our motion for summary disposition and hearing on that motion, and I believe that was submitted with our response to Ms. Price's filing, whatever that was, Your Honor.
Okay, and unfortunately, I have Ms. Price's filing. I don't think that I have your response. It didn't make its way to me in time to come home with me for the file. So I'll review that as well. But Ms. Price, like I say, there is documentation, and it is strictly required by the appellate rules. There's no way, sometimes in the lower courts, a judge can say, well, you're appearing as a sui generis pro se, a person appearing without an attorney appearing beside them, and I can give you a break on following some of the rules. That's not true at all on appeal. Appeal there, either you follow the rules or your appeal gets dismissed. It's kind of a black and white system in that regard, and that it doesn't give me very much discretion when I'm sitting in that appellate jurisdiction. So you do need to get that in order, and I'm going to have it ordered that it be done within 15 days. That's, I think, all we can
To the extent Ms. Price does supplement her appellate filing and the court finds that it is inconsistent with the appellate rules, will another hearing be required, Your Honor, or?
do. No, I'll just sign an order of dismissal if I don't have the proper documents to initiate the appeal.
Terrific. Thank you, Your Honor.
Very good.
Your Honor, you said I have 15 days to get the information because I believed I sent all of this stuff in appropriately. I went into and handed it in and got the proper documentation. And the fact that you said you don't have that information is a little.
Yeah, no, I do have a bunch of
about it.
stuff that you filed that appears to have been printed out by you. The one thing I have, and the only suggestion I can make, Ms. Price, there is a legal assistance center on the 4th floor of the courthouse. If you talk to them and say, gee, Judge Rossi said I was missing some stuff on appeal, they can at least direct you to the proper forms to file to initiate an appeal. Because the one thing I did receive here, was the notice of filing of transcript and affidavit of mailing, and that's on a Michigan court form that I recognize. And what I then got was a transcript of that hearing, the last hearing, it appears, in front of Judge Sturkenberg. However, there is more stuff. They need to, what really they need to do is transmit the entire record of that case, or you as the party need to assemble that record on appeal, the record of what happened in the lower court, and get it to me on appeal. And that basically looks like those transcripts plus any paper documents in the court file that happened in the district court. And I don't see any of those in my appellate file here.
They told me that I put there that they was going to mail it to you. They mailed me a copy and they said they was going to mail you a copy because I purchased the transcripts and everything.
Yeah, and I did get the transcript, but that's just the transcript of the the hearing on appeal, and that is part of what I need. I said I didn't have a claim of appeal. I stand corrected as I'm paging through here. And I have to tell you, Ms. Price, the filing of the additional documents here, I know you believe it's important in helping me to decide your case, but I can tell you what it's doing in a practical sense is making it really hard for me to file, just to track the documents that actually do trigger my duty to decide stuff on appeal. So I do have a claim of appeal. Looks like it was signed by you on June the 13th of 2025. So really what I need on appeal then, and again, I'm also prohibited, as the folks at the Legal Aid Center are, from giving legal advice. But I can tell you, if I'm to decide any appeal, I'll need a copy of the entire lower court record on appeal. And the record on appeal, like I said, usually it's assembled by the parties to the appeal. Usually you, as the person, the individual appealing the decision of Judge Sturkenberg, are the one that's going to put that together. Mr. Bequicchio can contribute to that record if he wishes to do so. And then that gets submitted to me, kind of as a, here's what happened at the lower court. It tells the story of that in those filings and pleadings filed at the lower court. And then you file a brief on appeal, and your brief makes the arguments as to why Judge Sturkenberg made legal errors in her decision making. And since I'm requesting that brief now, I just thought I was needing the claim of appeal, but since I have a claim of appeal that properly initiates the case on appeal, what I really need then is that record on the lower court, and then I need a brief from you explaining the errors that you think Judge Sturkenberg made. And I'll tell you, I will not be receptive to documents telling me that Judge Sturkenberg or I didn't have jurisdiction. That would be, in effect, saying, Judge, I'm arguing that neither of the courts could really decide this case because of my legal status, sui generis, or, whatever, magic words you're trying to invoke there, that just doesn't work. And the reason it doesn't work, particularly on appeal, is I have to have jurisdiction to decide the appeal in the first place. And if you're telling me I don't have jurisdiction, you're as good as telling me, as judge, dismiss my appeal because, you can't decide it anyway. And so in other words, you got to give me more than that. It's got to be an argument based on Michigan law as to what mistakes were made by Judge Sturkenberg in the court below, and then I can decide the matter on appeal. And since I'm looking for the brief on appeal, that's a little harder to put together along with that whole record. I'll extend the time for the filing of the record on appeal and your brief on appeal. I'll give you 60 days from today's date. We're at July the
25th.
25th. Yeah, sorry, my glasses. I'm using a backup pair of glasses because my regular ones are in the shop. So 2 months from today will bring us to September 25th to have those documents filed. And then I'll be able to decide those. And I'll also tell you, Ms. Price, the way it works on appeal is I don't need to grant. You can request oral argument, which would be another version. Today, really, this is more of a status conference. It's not so much oral argument because I couldn't make head or tail of what the file was asking me to do. You can request oral argument if you want it. I don't have to grant it on appeal. Sometimes I just review the record and the filings and, decide the appeal based on that. And of course, Mr. Bequicchio, after that 60 days can file whatever he wants in response to your arguments on appeal. And likely that'll be a motion to dismiss the appeal saying Judge Sturkenberg did everything right and there's nothing to look at here, folks. So that's kind of how it works on appeal, just for your information. And like I say, if you need help with at least the forms part of it, the Legal Assistance Center on the 4th floor of the courthouse is a good resource for that.
Okay, so am I, just for clarification, because I'm going to do this right this time, this court.
Correct. And the record.
And you need a complete record of the two hearings that had taken place.
I need the complete record from the lower court, and that would start with everything from Mr. Bequicchio's complaint that he served you with and the proof of service and all that stuff. Typically, there's a copy of it. Would be as if you grabbed the file from Kentwood and made a copy of every piece of paper in it.
Okay.
Plus the transcripts.
Okay. Plus, you still need the transcripts as well?
No, you already filed the transcript. If that was the only hearing in the case, were there other hearings?
There were none, Your Honor.
Okay, so that was the only time that you two argued in front of the judge. So I don't need any additional transcripts. I just need the record on appeal.
Your Honor, there may have been a pretrial. I can't remember whether or not that was on the record or not, Your Honor. But if it is indeed on the record, the lower court record would include that, of course.
Very good. All right, so that's what I need, is that record from the lower court. Mr. Bequicchio, I think the appellate rules allow you to weigh in and supplement the record or collaborate on submitting the record to me. I'll leave that to you as to how much you're going to participate and assist with that production. But you two can talk to each other. The goal being to get everything in front of me that I need to decide the arguments that you make in that brief on appeal, which is where you get a chance to make your substantive argument as to any errors made by Judge Sturkenberg.
Thank you, Your Honor. I will say, to clarify from our position, we did respond to the filing of Ms. Price. With that, we included the complaint, the answer, and our motion for summary disposition, and Ms. Price's response to that motion for summary disposition. So that should make its way to the court file. I don't know whether that would be deemed an official record as far as the appeal is concerned with certified documents, but we did put the underlying materials in our response.